in the matter of petitioner Charles Paul Nerswick versus respondent Lindsay Ann Dineski. Ms. Dineski, please state your name for the record.
Lindsay Dineski.
Please raise your right hand. You solemnly swear to affirm any testimony you provide to the court today will be the truth and nothing but the truth.
You always tell the truth.
Hey everyone, welcome back. Today we're diving into part 4 of Lindsay Dineski's story, and this one takes a sharp turn. Lindsay was recently arrested after refusing to step out of her vehicle when ordered by police, a risky move, especially with a warrant already out for her. I've requested the body cam footage and we're waiting for approval. In the meantime, let's break down what happened next, in the courtroom. Let's get into it.
A bench warrant to issue for your arrest back in December 4th, 2003.
There was no service on that. I was never given any service on that warrant, so it's invalid.
So the warrant issued because you failed to appear
For a court that I never received any service on.
for the show cause hearing. I do see that proof of service.
I was in another state, so there's no way I received any proof of service, and you guys had my email and my phone number, and nobody ever contacted me, so this needs to be thrown out immediately.
So that's not how the court.
Yes, the law says. The law says if I do not have...
That's actually true, but in Lindsay's case, it doesn't help. She moved and never updated the court with her new address. Under MCR 2.107, legal papers can still be sent to the last address on file. Bottom line, whether you move out, get evicted, or leave for any reason, you must tell the court. If you don't, you can still be legally served at your old address. At this point, the court pauses to double-check that service was properly handled. Watch how Lindsay jumps right back in when the judge returns.
Okay, Miss.
Me into trial on this matter because I've never been able to present any evidence.
Be quiet.
This is my hearing and I'm allowed to speak at my own hearing.
I have to let you know I'm arraigning you.
You're reading it on an invalid warrant. This needs to be dropped immediately. Is this an Article 1 court or an Article 3 court? Because if this is not an Article 3 court, you have no right to adjudicate anything to do with my liberty interests. And my children are my liberty interests, and they are my offspring, and this man attacked me, so this entire PPO is based on fraud and is void. So that not only can you not arraign me, but you need to overturn the PPO immediately.
So, Ms. Dineski, you were served on October 23rd, 2023. There was a show cause hearing for a violation of the PPO that occurred on December 4th, 2023. Just for the record, I have muted Ms. Dineski because she refused to be quiet.
You're not allowed to mute me at my hearing. Is this an Article 3 court or an Article 1 court, ma'am? You have to answer me. Are you an Article 1 judge? Because if you are, President Trump said that you are not allowed to hear anything to do with my liberty interests in his executive order that he recently put out.
All right.
Are you Article?
Is that you stopped Mr. Nerswick's mail? You were interfering with his mail, Ms. Nerswick, and wasn't able to receive his mail.
If you do not have a constitutional oath, then you have to recuse yourself immediately and let me have an Article 3 judge, because this has to do with my constitutional rights. And Article 1 judges.
So the court is in receipt of a customer information form that
You do not consent to this PPO, and you must prove and show your oath.
USPS at an address of 18337 Ewell Road, Belleville, Michigan.
I was not living there. I had been evicted from there previously in June, so there was no proper service.
The petitioner filed a motion complaining that you, Ms. Dineski, stopped his mail.
I didn't stop anybody's mail. He came and stole my mail and signed for a certified letter that he sent me, so I didn't receive it. And you guys won't let me show evidence. This has been going on for over a year, and I've never once been able to show evidence, and I've demanded a trial multiple times, and you've denied me a trial. So you're going to be going to prison under USC 18 241 and 242, and I'm going to be asking.
It's honestly a bit amusing. Lindsay seems to hand out extreme consequences to just about everyone, and yes, she's even joked about that with me a few times. At this point, it's probably best to take it with a sense of humor. Up next, Lindsay's left alone on the video call, and that's when she starts talking to herself. Let's see what happens.
This is also a bill of pain and penalties, which has been outlawed by the Constitution, Article 1, Section 9, Clause 3. You are using an unlawful PPO to withhold me from my offspring, which qualifies as kidnapping and hostage taking and treason and torture. This matter is void ab initio from the beginning because it's based on fraud, and fraud vitiates everything. Marbury versus Madison, anything repugnant to the Constitution is void. This is a violation of my free speech. This is a violation of my right to petition the government for redress of grievances. It's a violation of my Second Amendment because you said I couldn't have a weapon or bear arms.
Ms. Danelski, I'm gonna put you in the breakout room with Ms.
This is a violation of my Sixth Amendment. This is a violation of my Sixth Amendment. This is a violation of my Seventh Amendment. This is a violation of my Eighth Amendment right, my inalienable Eighth Amendment right. This is a violation of my Ninth and Tenth Amendment rights. You are violating all of my rights, and I have not ever been allowed to be heard. Due process allows me the right to be heard, and this has been ongoing since 2023, and I have never had the right to be heard. And I've had my babies unlawfully held from me based on fraud, which I never got to present evidence to prove otherwise.
Lindsay keeps talking nonstop throughout the hearing. At one point, the judge steps away briefly and returns with an update. The hearing will be delayed for a few hours while they wait for a prosecutor. Normally, a hearing like this can move forward without one, but this case is a little different.
Okay, we don't have a prosecutor. I'm putting this over. Can we, I want to reconvene at 2 o'clock.
I'm demanding a quo warranto.
All right.
And I need
Deputy, did you hear me? Officer?
Your Honor, I do have a 2 o'clock. Did you want me to come back? I have a 2 o'clock in
I don't need an attorney. I don't consent to an
Yeah,
attorney.
I can't. I don't have a prosecutor. I need you to come back. What about 2:30?
I want to say something. You guys are. I've talked about
Williams,
Your Honor, I'm talking to
5 days.
I
I've been
have
here for
no
5 days.
prosecutor.
I was not even notified of this court. I was not even given notice of this court date, and I've been here for
So
5 days.
Mr. Nash,
let's
please
say
be quiet.
1:45. I don't have a prosecutor.
You need to be
I can't
quiet.
do
This is
anything.
my hearing.
Can we do 1:45, officer?
Yeah, 145.
Okay,
All right, we'll
I'll be
see y'all
back at
back at 1:45.
Okay, thank you, Your Honor.
I do have one question.
Go ahead, officer.
Just for staffing purposes, can you give a time, because that's right around shift change, do you think that hearing would be done by 2:30, or are
I'm
we
waiting
looking
on a
at
prosecutor.
2:30?
I can't.
Well, it has
The
to
record is
Your Honor, I
going
have
now.
a 2
I
o'clock.
can't call
I'm
it. So
a prosecutor. I'm asking for this to be
Okay.
dropped.
yeah, 1:45 is the time that I have.
Why won't you
Okay.
answer any of my questions?
Your Honor, I'll see you at 1:45. Thank
Sounds
you.
good.
You just ignore my questions.
A few hours later, the prosecutor arrives and the hearing picks up right where it left off.
Arraignments can take place without the prosecutor's office, but
I kind of thought
Might
so. I
be.
did start, but for this particular one,
Yeah, this one, I think.
considering the fact that, you know,
yeah,
I've been, this is, we needed you here. That's why I started off and I was like, oh no, let me.
Leslie, as far as the allegations go, I do believe that this is a bench-born arraignment.
Hold on.
Oh.
Yep, it is. Let me start to call the case. All right, CJC, are you there? I want to call the case, but I want to hear from you.
Yes.
All right. All right. Thank you. Let me call the case.
Recording in
This is
progress.
case number 23-104850-PP in the matter of Charles Nurswick versus Lindsay Ann Daneski. Mr. Tudge, if I could get your appearance from the prosecutor's office.
Good afternoon, Your Honor. Gregory Tudge, P85961 for the people.
All right. Miss Fort Williams, your appearance, please.
Good afternoon, Your Honor. Gail Fort Williams, P35963, Counsel on behalf of Ms.
All right, Ms. Fort Williams, you had an opportunity to speak with Mr. Daneski in the breakout room.
So why is there still an attorney on my case when I said I don't want one?
I attempted to speak with her, Your Honor.
I do not want or need an attorney.
All right, Ms. Fort Williams, I just want you to stand by at this time, if you can do that.
And I'm entitled to relief from judgment under Michigan Court Rule 2.612 because I was not personally notified of this matter. And so it needs to be dismissed immediately.
Ms. Daneski, you were arrested for a warrant issued because of your failure to appear.
A failure to appear on something I was not personally notified on. So under Court Rule 2.6123, not personally notified, I am entitled to relief from this proceeding and action.
Let me hear from Mr. Tudge. Go ahead, Mr. Tudge.
Your Honor, it does appear that the 2.512, I believe, was the citation, which 2.516.
I'm sorry, 2.612.
Chapter 2 of the Michigan Court Rules governs the civil procedures. This being a quasi-criminal matter,
This is a civil procedure because it's family court.
Hold on, Ms. Daneski, let Mr. Tudge speak.
It's not quasi-criminal, this is civil.
All right.
So that's